Michael Trout. I'm from Boca Raton, Florida. When my niece was 6 years old, her mother, my sister, died on the table in a DeKalb County hospital just outside of Atlanta. Although the medics were able to bring her back, it was as though at the age of 36 she'd suffered a massive stroke. So fate had stolen my niece's childhood. She was transformed from the cared-for child to being her mommy's caregiver overnight, a challenge that she accepted with grace and love for the next 7 years. Weeks before her 14th birthday, bad actors in the state of Georgia would conspire to steal her adolescence. My niece was involved in a brief, consensual, sexual exploratory encounter with her best friend, a 14-year-old female, 2 boys, one 14 and one 16. It was the kind of awkward thing that countless adolescents experience on the journey to adulthood. What little maturity the teenage brain has acquired by that age is quickly overwhelmed by the burning curiosity and the maddening hormones that are set free upon it. On a March afternoon at about 4:45 p.m. in broad daylight, my niece's parents dropped the girls off to walk to their church youth fellowship that started at about 5:30. They stopped at a skate ramp park along the way, not 50 yards in front of the front door of the local police station, where they had happened upon 2 boys. Of course, the boys expressed a desire to take things a little deeper, but the girls declined and the boys walked away. But then, using my niece's cell phone, her friend called them and invited them back, saying they were bored. When they were returned, there was some sort of sex play, but as some other kids appeared to be approaching, it ended as quickly as it began, and the kids went their separate ways. The girls arrived on time to their youth group and went home afterwards together, where my niece's friends stayed over and spent the night. A couple of days later, in her regular mental health counseling session that she had every week, she relayed some of this story to the therapist, and the therapist interpreted the event to be a potential violation and notified police authorities. So on or about Thursday, April 12th, 2007, a school resource officer called my sister and asked if he could speak to my niece. My sister asked him if her daughter was in any kind of trouble, and he replied no, at this time she wasn't in any trouble. Just the same, my sister had the presence of mind to refer the officer to her husband when he came home from his job as a correctional officer at the county jail. He called the SRO, and when he inquired what this was all about, the officer clearly told him that this was nothing, just regular high school stuff. And with that, her father gave us permission. He didn't know that the police were already planning to charge her with 2 capital felonies, and that the purpose of the interview was to obtain a false confession and evidence to bolster their charges, specifically sexual battery and false imprisonment. On Friday the 13th of April 2007, my niece was separated from her classroom and unlawfully interrogated without legal counsel or the presence of her parents or even an adult friend. My niece states that more than once she reported to the officer that she wanted her mommy, but the interrogation continued, unrecorded, and finally resulted in a highly prejudicial and coerced 2-sentence statement, upon which she was arrested, taken into custody, and sent to a juvenile detention facility. My niece spent the next 2 years in several detention facilities all over the state of Georgia. She was moved every so many months without any particular explanation or rhyme or reason. I once sent her a publication by the National Juvenile Defender Center that was meant to educate her on the role that her attorney was supposed to fill and about her general legal rights. She reported that the guards at the facility took it away from her, even though it's a bona fide legal resource that she had a right to have. When her attorney, Brett Mazerak, finally claimed to have a deal with the prosecutor to free her on time served, a hearing was scheduled for October the 9th of 2009. Mazerak arrived late to the hearing and had no consultation with his client. It's typical for the defense or the prosecutor to draw up orders based on their agreements for the judge to sign. Since we haven't had the opportunity to review the transcript of the 10-9-09 hearing, we can't ascertain who in fact drew the document, but it's clear that it wasn't the judge, because upon his review of the order, he struck the section granting time served for all the time that my niece had already been in detention, nearly 2 years, saying that it contravened Georgia law. So that document itself proves that my niece's lawyer was incompetent in this very critical instance, inasmuch as it deprived his client of her most important plea, which was to be finally granted her liberty. Upon that discovery, in that hearing, an ethical attorney would have moved for time to consult with his client, which he did not. An ethical judge and prosecutor would have moved for a recess based on the obviously flawed representation of counsel, who clearly did not even know the law that applied to his client's case. My niece was remanded back into custody on that day when she had expected to be released. It was a terrible blow to her family, including me, and to the very notion of justice. My sister wept and wept for her baby girl. In 1967, the landmark case In Re Gault was supposed to settle matters of due process for juvenile defendants in the country. That was over 44 years ago. But in fact, every day in America, juvenile rights and due process rights are routinely trampled.